Hello everyone and welcome to our second video tutorial on judicial precedent. In the first video we looked at an overview of precedent and we also looked at how court hierarchy is necessary in order for precedent to work. In today's video tutorial we're going to be looking at the second and third requirements for precedent to work, i.e. ratio decidendi and law reports. So just as a quick reminder to you then, precedent is all about how judges use a decision from a previous case to help them make a decision in a case in front of them today. And it's based on stare decisis, to stand by what has been decided. And what we saw last time was that with the court hierarchy, the higher courts bind all the lower courts, and in general they bind themselves. And we're going to look at the next requirements we need in order for precedent to work, starting with ratio decidendi. So if we go to ratio decidendi then, we're already familiar with this term from our study of criminal law. It's a little bit of Latin meaning reason for deciding. And we know that ratio decidendi is the principle of the decision. It is always red on your slide to highlight the fact that it's really important. And it's really important because it's the part of the case that will be followed. And in every case, you will get a judgment. Sometimes they're very long, these written judgments. And within the judgment, you will have a statement of all the facts. You will have the ratio decidendi will be in there. And things that are important but aren't as important as the ratio, obiter dicta, will be in there. I'm going to come back to that shortly. And you'll also get the decision or the verdict in the case. But the ratio, we know, is the thing that's going to be followed in future cases. That's what you've been busy memorising for all your criminal cases. Now, I just wanted to show you very quickly on screen a real case judgment so that I can show you how all these things appear in the judgment. So I've just switched my screen over here to show you a real court case judgment. And you can see, if I move it up here slightly, it's 22 pages long, this judgment. There are some that are much longer than that. There are some that are shorter. This is a case that we've studied. This is why I've picked this one to show you. This is the sad case of Alfie Evans, and this is the judgment from the High Court. So you can see here, these are the justices or the judges that were in the case. And we've got here Tom Evans, which was Alfie's dad and Alfie's mum here. And you can see that they were bringing a case, as we know, against Alder Hey Children's Hospital. And if I scroll down, I can show you the judgment here. So we've got the judge on the case, Lord Justice McFarlane. And if I scroll down, you can see that the judge is describing the facts about Alfie here. So it's talking about Alfie's birth, the fact he'd had a fairly normal pregnancy, or his mum had a normal pregnancy, sorry. And then it goes on to tell you how, unfortunately, problems with Alfie were discovered and what happened. And you can see here, if I scroll down, he talks about things that other judges have said, things that have helped him to make the decision in this case. And you can see it's quite detailed. And in this judgment, you're going to have the ratio decidendi, you're going to have obiter dicta, and it's the lawyer's job to pull that out from the judgment. Now, we already know what the ratio decidendi was in the case of Alfie Evans. It followed another case that we've studied, the case of Bland. And the judges here decided that they were going to follow Bland and that life-saving treatment can be withdrawn from a patient when it's no longer in that patient's best interest. And that was the decision that was made in this case. Which obviously wasn't what Alfie's parents were hoping for. But the reason I've just been showing you this on screen is just to help you picture really what a judgment looks like. So I'll just switch back now to my other screen. To our PowerPoint then, I'm going to go on to this next slide. So I was just showing you the Alfie Evans judgment from the High Court. And what I was trying to show you is that in all that writing, all of that speech, that judgment from the judge, there will be in the ratio decidendi, which is binding precedent, and there will also be in there obiter dicta. Now, ratio decidendi is the reason for the decision. Obiter dicta, a bit more Latin, this stands for other things said. Now, this bit doesn't have to be followed, but a judge may choose to follow it in a future case if they want to. So what we're saying is you have to follow this bit, the ratio, that's why we memorise it, and you might choose to follow this bit. And that's why it's called persuasive. You don't have to follow it, but you might be persuaded to. And to illustrate how this works, I'm going to show a couple of case examples on the next slide for you. So if we have a look at some examples of ratios here, there's the case of how, which we've studied in criminal law when we were doing duress. And the ratio in how was that the defence of duress was not available to a charge of murder. In the case of Brown, this is another example we've studied in criminal law. The ratio was that consent was not available for offences under section 47 and under section 20. And that was policy grounds. And Donahue and Stevenson's a really important case that we'll look at next year. And the ratio here was that manufacturers owe a duty of care to the ultimate consumers of their products. I could have chosen any of the cases we've studied here to give you examples of ratios, but I've chosen these ones because they're very famous cases, they're very important. Donahue and Stevenson was very important because it also gave us an original or a new precedent. So what that means is when a case is decided for the very first time, this was the very first time that manufacturers were held to owe a duty to the ultimate consumer, we call that an original precedent because it's brand new. So these are some famous examples of ratios, you know, hundreds, but I want to come back to or and how, because the case of how will show us the difference between ratio decidendi and obiter dicta. So if I go on to my next slide here, we've got obiter dicta, which I've already told you means other things said or things said by the way. So in how, the ratio was duress was no defence to murder, and that was the bit that had to be followed in all future cases. But in the case of how, the judge also said something else. And in his big long judgment, there was some obiter. And the obiter was duress is no defence to attempted murder. Now, this wasn't ratio in the case, it was obiter. And it wasn't ratio because in that particular case, it did involve murder. And so the binding bit was about murder. But the judge said, oh, and I think, you know, if it was attempted murder, this would apply too. So that wasn't binding what he was saying because he was giving his thoughts, giving his opinion. It wasn't really relevant in that particular case. But if you think about that, if you've got a House of Lords judge who at the time, you know, highest judge in the land saying that he thought this might be the case, then you can see how a judge in a later case might choose to follow that obiter, even though they don't have to. And that because it's quite an important judge saying it, it's persuasive. It might persuade a future judge to follow it anyway. And that's precisely what happened in the case of Gotts. So in the case of Gotts, the court decided to follow the obiter dicta from the previous case of how, and they said that the defendant was guilty of an offence because duress is no defence to attempted murder. And the really clever thing here that happens when cases are adding to each other like this is that we got this obiter in how, duress is no defence to attempted murder, that was just persuasive. But when the case of Gotts decided to follow that, even though they didn't have to, this duress is no defence to attempted murder becomes ratio. And that's why I've put it red here, because we're used to seeing our ratios in red. So if a judge decides to follow the obiter and he applies the obiter, then the obiter then becomes a new ratio. And after the case of Gotts, we will know that duress will be no defence to attempted murder either. So you can see here how precedent is working, because these cases are giving guidance to a judge in a future case. So any case involving duress and murder or attempted murder, the judge can look at these cases and that will help him to make a decision in the case in front of him. And these are going to be binding, these decisions on him. And it might be useful at this point just to challenge yourself, really, just to maybe pause the video at this point and just write down as many ratios as you can from all the criminal cases we've covered so far. So just maybe give yourself 5 minutes, write as many ratio decidendi as you possibly can, because that's a nice revision task for criminal law as well. And then once you've done that, come straight back to me. So hopefully you got hundreds of ratios down on your paper there. Let's get back to looking at precedent. So what we've looked at then is court hierarchy. We've looked at ratio decidendi and we've compared that to obiter dicta, and we've seen that ratio is massively important for precedent to work, because of course in order to follow a past decision you have to have an important thing that you are following. You have to have a rule that you're going to follow. So the last bit we need to look at in this video won't take us very long at all. We just need to have a look at what a law report is. So law reports are the third thing that we need in order for precedent to work. And a law report, you've got a definition here, is a written record of a court case. And of course, that's going to be vital for precedent to work, because if we don't write down the judgment of a case and record it somewhere, we can't possibly follow it in the future. If you think back to some of the cases we've already studied, Tuberville and Savage, for instance, that was from 1669. If someone hadn't written that case down in a law report, we wouldn't know it existed, and we wouldn't be able to follow the ratio from Tuberville and Savage, which is that words can negate an assault. So we need to have it written down. And I've put here that a single case can be reported in more than one series of law reports. So it's a bit like the news. One news story will be repeated in lots of different newspapers, and it's the same with law reports. As I've already said, they're vital for precedent to work, and a law report is a record of the issues involved in the case and the decisions of the court. And it includes, as you can see here, the title, the case name, catchwords, head note, etc., the counsel who were in it. And I'm going to show you an example of a law report so that you can see what this means. So I've just got an example here on this screen for you. And you can see here, this is just showing you that the names of the parties are here, the court is here, you've got the judges that were in the case, the date of the case, catchphrases or catchwords. I think of this as a bit like being hashtag on Instagram, that it's all the key information that you're going to find in the case. We've got a head note. And if we were to scroll down through the case, you would see other cases that the judge has referred to, any cases that have happened before, so if it's on appeal, where it's been before. So what I was showing you there is what the law reports contain. So all those different things. There are different law reports, the Times law reports, the All England law reports, and they look a little bit like this. Often you see them on shelves behind judges' heads when you see them on the TV. And these are statute books. These are the All England law reports. So vital for precedent to work, because if we didn't write down what happened in a case, we wouldn't be able to follow it. So that's it for this video. Tune in for the next one.